Hello, good morning, everyone. Those who've joined already. 27 minutes past, a few minutes yet, and then we'll be making a start. Could one person just kind of reply back to me and say you can hear me? Just it's really scary here, thinking I'm sat here talking and perhaps no one can actually hear me at all anyway. Okay, that is a concern. Thanks, John. Lovely. Tony, thank you. That's great stuff. Okay. I'm sure that's always a worry for everyone, isn't it? That you're at a meeting and you're talking away and and no one can actually hear you. Anyway, it sounds like it's all okay. Yeah, as you join in, if I could just ask you to put your microphones to mute, that'd be great. And then we don't get any noise in the background and feedback and stuff like that.
Oh yeah, that's me, central surgery.
Who's that one? I can hear someone talking. Great. I think they've just muted it. So yeah, I'll just talk for a little bit because I know as people join these meetings, it's always useful to actually hear that there's someone there. Although you always get that worry you're joined halfway through and you're perhaps late, but I'm sure that won't be the case. I'll just waffle on a little bit so that people can be sure that there is someone here when they join. Beautiful, warm, sunny day here where I am, just on the south bank of the Humber. I've walked the dog 6:30 in the morning. I'm sure those of you who have dogs have got used to this routine now. But it was absolutely gorgeous first thing where I was out walking my dog, and he's now settled back in there. I can just see out the window here. He's under the shade of a tree where he's probably going to stay most of the day. I think it's going to be pretty hot today. Having said that, I won't take any complaints about people around the weather. I love it. I'm a real hot weather person, I have to say. Many years ago, I lived in Central America on the Caribbean coast, and it was absolutely fabulous for a couple of years. And so I'm a dedicated hot weather person. I don't take complaints about it. The only problem is, of course, in this country, we're not geared up for it, which is the problems that we have. I'm sat here in a stuffy little office in my house. Houses in countries where they regularly get hot weather like this are built to cope with it. So just a reminder, please to go on mute. I can hear someone answering the phone and things like that.
She should only be able to get into the meeting.
I wouldn't want to hear any
access to anywhere else in the building.
Overhear any communications. Whoever that is who's talking on the phone, we can all hear you. I'm sorry. If you can go on mute. Thank you. Cheers. Yeah, that would be well, could potentially be cause problems, couldn't it, if you're overhearing phone conversations. Lovely. Okay, the numbers are building up. Great stuff. It's 9:30, but I'll give it just a couple of minutes. Let me see if I can get my presentation started, because that would always be a good thing, wouldn't it? So let's have a look. Okay. Again, can I just ask someone to confirm that they can now see that front page to my presentation, which has a rather dodgy picture of me on it, I'm afraid, and some N3i stuff. Great, thank you. I can see it. So yeah, I'll give it another couple of minutes. What we'll do around questions and discussions, because the way the presentation is set up, I can't see the chat bit now, which I could see before, because I've taken over my own screen with this. If we can do that at the end, if anyone has any burning issues they go through, please just shout out. That'll be fine, and I'll pause a couple of times as we go along, and give the opportunity for questions. But anything significant, we'll do at the end. So let me just check on my phone. 9:31. I'm going to give it one more minute. I know we've got quite a good number already, and then we'll make a start. So I can start by doing introductions. I guess you all know me. My name is Barry Jackson, Head of Information Governance at N3i. This is one of a series of webinars. Slightly unusually, this yesterday, putting some finishing touches to it, and I realized I've actually got more text than I normally do. If you've heard me and seen me doing these webinars before, I tend to like to just have a few bullet points that I then kind of talk through. Because this is fairly new stuff to all of us, and some new concepts around managing deceased records, I've put some bits of text in, and I don't want you to kind of get worried about trying to read it and follow it as I go through it. So what I will do once we finish this morning is that I'll put the actual presentation itself as well as the recording, because this is being recorded. I'll put both of those on the IG portal, and you can download them from there, and then you can see there's also a couple of links in the presentation as well. You'll be able to follow those easier. So don't worry about trying to kind of catch up and read all the stuff that's on there. I do apologize. I don't really like doing too much text, but it was just important that there was a few bits that I think needed to be exactly as they were provided to us, if you like, because I have to say there are a few there's still a few questions around this whole process. It's changed in a very significant way in the way we manage health records, and it's been probably somewhat disappointing to say the least, the way in which this change has been put out. So we'll talk about that when we get to it, really. Okay, let's make a start then. So yep, that's me. Yep, introduction. So while I've got you here, under false pretenses, thinking it's all going to be about access to deceased health records, I just want to remind you about a couple of other little things. Patient online access to their records will start on the 1st of November. That's essentially when the clinical systems will be switched over. As we understand it, the whole systems will be switched over on one, presumably overnight. There's talk that some parts of System 1 may go on a regional basis, but I think the latest I heard is that it's all going to pretty much happen around the 1st of November. I'll be doing another webinar, or probably at least one, if not two, before the 1st of November to kind of summarize and pull together this stuff. But I think if there's one message about this, is that you need to be preparing now. You need to have staff aware. Anyone who accesses and inputs data into records needs to be aware of this and needs to have guidance on how they're going to do their jobs, essentially, how they're going to maintain clinical records after the 1st of November, when patients will have full online access in real time to their records. Okay. And that will be by default. The whole system will be switched over, so everyone will have default online access. We've talked about this before. It's been going, you guys know this, it's been going on for a long time, but you need to be ready for it. So that's a link. There are still some webinars that NHS England are running, and you can get them on that link. And as I said, when I send the presentation around, you'll be able to access that link directly. There is loads of stuff on their website, loads of information and guidance documents and stuff like that. But there are also the direct events that they're doing, and there are still quite a few to book on. I looked on that yesterday. I think every couple of weeks from now till the 1st of November, they're running these webinars. So if you want to do that, by all means go on those, and I'll run a couple as well to kind of summarize and pick out some of the more important points. But the main message is get on thinking about this now, have your team meetings talking about it, and make sure staff and clinicians are aware. Clinical system audits. I put a little note on the web portal yesterday about this. There is a significant issue with system audits where, if you're a practice that runs System 1 and you have the AccuRx system in place, the way it works, when it's doing some of its automated functions, so if AccuRx, for example, is as a system is checking in the records, let's say, of people who have appointments tomorrow, it'll do a check the day beforehand to make sure they've got a phone number in place, to make sure they're still alive, for example, and a few other things that it'll check, and that's like a system check. But that access to that record will be allocated to a person within your system. So any user essentially could have that access allocated against them. It doesn't come up as a system access. It needs to allocate a person against it, and it does that on a somewhat random basis, we think. What it means is that if you subsequently go into a patient record, you may see that an individual is in the audit trail marked against the fact they've accessed that record. It may not actually be the case. They may have been just picked up as part of the automated system. So what I would say is, Two things. First of all, if any of you have had issues with staff over the last probably 2 years since Accurex has been in place, and you think you've had an inappropriate access by someone who potentially said, well, I didn't access it, because they wouldn't necessarily know how the system works. You're saying, well, the audit trail says that you've accessed this record, and they're saying they didn't. Please let me know, because that's the sort of stuff that's really quite important to us. And going forward, you should just be aware of that. They are putting in a fix for this, so that it will actually show that it's a system entry, but at the moment it's still not there. So if you have any problems with clinical system audits, simple message I think really is to give me a shout, and we'll talk it through, but just to be aware of that. And finally, I think incident reporting. I got where you report incidents through the Datix system goes to what used to be the CCG. Don't know where it goes now, to be fair, and they often get reported back to me. So I did receive an incident the other week, which actually should have come to me direct. So this is just really a reminder to your practices, where all the practices out there, if you have me as your data protection officer, and I know not all of you do, but where you do have me, if you have a data incident, please ensure you report it to me first, or you certainly include me in that first set of reporting alongside Datix and whoever else you're reporting it to. That's really quite important, because there's some legal issues. GDPR requires certain things to be reported further on, and there's some fairly short timescales on that. So please don't forget to be including me in those incident reports. Right, on to what we're talking about. The management of deceased records. So the GP contract for this year, the changes that were announced in the 2022-23 contract, said this basically, and this is one of my bits of text which I've actually copied from the letter that was sent out on the 1st of March. I thought it was important to have exactly what it says. So the letter from NHS England around the GP contract changes had this little paragraph in there, which has two elements to it. So it says it will require GP practices to respond to Access to Health Records Act requests for deceased patients. So it's probably slightly the other way around. If we do the other bit first, and it removes the requirement for practices to print and send copies of the electronic records back to PCSE. So let's look at that bit first. As you know, at the moment, you're sending the printed record back along with the other paper elements that you've got. Basically, NHS England are saying you don't have to do that anymore. So good for the environment, good for all the trees, good for your costs of buying paper, I suspect. I think we did some work on that with one of the practices last year when I've been pushing for this for years. It just seems a very strange thing to still have in place in a modern electronic healthcare service, that it works great until you die and then we print off your record. So eventually they've decided we don't have to do that. Like I said, as it says, the other side of that is that because you will hold the record and you haven't given it to anyone else, you will have to respond to requests for someone to access to it. And there are a small number of people who can have access to it, which is exactly what we're going to run through in a moment. All requests to access information around deceased individuals come under this thing that's listed in the Access to Health Records Act. So it's a different piece of legislation, but that's what we're going to do this morning. We're going to have a slow, fairly high level walk through that legislation, just to help you understand, and we'll probably do some more in-depth work as we go forward and we start to see some of these requests coming through. The last bit of the paragraph there is something that NHS England have put in, one of those to kind of sweeten the blow, if you like. I guess I suspect everyone will have different views on this. So they have said it's their expectation that the savings from not having to print and send the electronic record will far outweigh the additional burden of managing a small number of Access to Health Record Act requests. I think that's, I don't know how they can make that judgment. They've got very little to base that on, other than, I suppose, you kind of, yeah, the figures would suggest that would be the case, but I'm not sure. So basically, you're moving from having to print out every single patient record, but that, obviously it's a quick process, but it's a fairly automated process. You're not really processing the data anymore. You're just simply printing everything and putting it into an envelope and sending it off. Very simplified version of it, I know, but you're not really having to do a whole lot of work on that. The small number of requests you will get from all the patients, obviously, who die and where you have to print their full record off, to move to a smaller number of those patients where people will ask to have access to the record. When you get those requests in, you have to do quite a bit of work, and we're going to go through that obviously in terms of complying with the access to health record. It's not straightforward. It's something different. It's not just, oh, well, we do this for Data Protection Act already for subject access requests. It's very different to that. So I'm not sure that's true. I don't think it's a huge burden. I don't think it's going to be massive, but it's still a case of suck it and see, I think, at the moment. So we've got that bit. That was what was sent out on the 1st of March. There was an expectation, I think, that at some point we'd be notified when this actually operationally came into effect, and that we would get some guidance, and they'd say, okay, well, you've changed from basically a centralized team who deals with all these Access to Health Records Act, a small team at PCSE, subject matter experts who do it all the time, to passing the responsibility back to 9,000 GP practices across the country. You might get something around that, around a bit of guidance to help them and so on. Clearly that hasn't happened. Whether we missed it or not, I don't know. However, I think most of you saw that the announcement from PCSE on the 2nd of August, that the change in effect had come into place on the 1st of August. So essentially it's in place now, this change. So with immediate effect, with effect from now, stop printing records, save a few trees, hopefully save your printing, your paper costs as well. However, you also may find that you're going to get some of these requests. What I would say at the moment is you certainly shouldn't be doing them if you're unsure. If you get a request yesterday or today or tomorrow, take time to think it through. And if you're not sure because no one's given you any guidance, then don't do it. Obviously, come to me and we'll talk about it. But I think it's pretty unfair to be expecting you to take on this additional responsibility at the moment without really having given you much information to help. I noticed the PCSE announcement simply gave you a link to the actual act itself, which is probably just about the most unhelpful thing that they could possibly have done. Okay, that's where it's come from. What's the next bit. So I put on you the very basic outline of the current process just to help us understand where we're going with this. So the GP practice mark a patient as deceased on the clinical system when they get notified of it, print out the full electronic record, add that to any paper record that they've got and the Lloyd George envelope, which all then gets sent to PCSE. There's a gap in some of the stuff that's coming out that I think assumes that there isn't any paper record. And also, we have absolutely no idea what's happening to Lloyd George envelopes. They have a special legal status, although there is a program to not to issue them to newborns anymore, I think. So it's not clear exactly what they mean by this, but that's the current system at the moment. And PCSE are responsible for managing request and access records because they have the full record at that point. They have both the paper record and the printout of the electronic record, which creates a full paper record, if that makes sense. So they've got both bits of it. And that's why up till now, we've always referred requests for access to records to PCSE. And they will keep a record, you probably know this, for 10 years. So they keep the record for 10 years, after which it gets destroyed. So I probably mentioned the unanswered questions, and this is really just for your information. And you can be absolutely sure that I've asked NHS England for some guidance around this, because I think it's pretty unsatisfactory that you haven't been provided with it yet. But these are the questions that I've posed. You may have some yourselves, which I'm more than happy if you want to send to me, and we can add into this sort of log of questions. So as I mentioned, records are held for 10 years. So there's a whole set of patients who have essentially died in the last 10 years where PCSE have the full record. Essentially all the ones who died 10 years back up to the 1st of August. What's going to happen to those records? If you get a request for a record that goes back pre the 1st of August, where you'll have sent the record back to PCSE, what's happening with that? As far as we know, and as you'd always assume, that PCSE have been given a contract, or an element of their contract has been maintained for them to keep doing this work. But it's again not entirely clear. This is an interesting one. Clinical record systems, going back to when they first put in, I think there's probably some concern around how they work. Early days, people were still getting used to them, and a decision was made not to delete information from them. in case, for whatever reason, back then, we're talking probably about early mid-90s, it was decided that you wouldn't delete information from a clinical record system, and that's still the case. Records still don't get deleted from many of our clinical record systems. But what it does now is it puts in that record management thing where we're saying, okay, deceased records are held for 10 years. If they're never deleted, are they held forever? Is that, and then how do you judge in terms of access to records? If you've still got the record on your system, should you provide it, even if it is after 10 years? So we need some clarification around what the clinical record systems are going to be doing here. And then I've said, I do really think PCSE, if someone's been doing the job for however many years they've been doing the job, and then you give it to someone else, you think, oh, look, here's all the guidance, here's the help manuals, here's the stuff on how we do the job. You might just find this useful, rather than just saying there's a link to the legislation, get on with it. So that's, yeah, so we're going to ask them to do that. And I say, I've sent it to NHS England. If any of you think of anything else, just let me know and I'll add that in there. Okay, another bit of text, I'm afraid, but here we go. So the Access to Health Records Act, this act has been in place for a long time, 1990, and it predates the Data Protection Act. So what happened is this act was put in place in 1990 for the access to any health record, including a living individual. It was, and 1990, of course, predates most electronic systems coming in. So it's a slightly outdated piece of legislation. And when the Data Protection Act came in, essentially it superseded the Access to Health Records Act for everything to do with living individuals. So the Data Protection Act, by definition, in its first paragraph said this applies to any living individual. It doesn't apply to the records of deceased. So the Access to Health Records Act was kept on the statute books purely to deal with rights of access to deceased records. And as it says here, it provides certain individuals with a right of access to their health records. The individuals are defined as the patient's personal representative and any person who may have a claim arising out of the patient's death. It's a very odd thing, and I think most people find it quite strange the way that's defined. But we're going to look into it a little bit more in a moment. But you've probably potentially already spotted that the most significant group of people who aren't listed there are the patient's immediate family and their next of kin, or however you kind of define that. They are not listed as having automatic access to a deceased person's record. But we'll talk about some issues around that in a moment. But they're not, the law doesn't define them with a specific right of access. A personal representative is either the executor or the administrator of the person's estate, and then someone who has a claim, obviously it's pretty much what it says. So just 2 points to bear in mind here. Whilst we're talking about the very legal side of access under the Act, we still have the common law duty of confidentiality, which is a less defined concept, but the concept of confidentiality runs through everything we do across healthcare. Professional conduct, contracts, contractual of employment will say maintain confidentiality and so on. And I put the GMC and the NHS, I saw something really useful from the BMA as well. Any organization, any national body like this will say that in their view, records of deceased individuals have the same level of confidentiality as if they were living. We owe a duty of care and a duty of confidentiality to the records of individuals, including individuals who have died. So that's fairly clear from all the national bodies. And this is more of a reflection, really, I think, from some of the things I've gathered speaking to other colleagues who dealt with this type of stuff before. The reality is that most requests for access to a deceased person's record will relate to the probate, to a will, inheritance, and then potentially claims from treatment and the death of the patient. And the fact is that money will cloud people's judgment. So, when you're being hassled by a lawyer to give access to a certain record for something, potentially it's just because Aunt Gladys is waiting to get her money from the will so she can go off on a world cruise that she's got earmarked the money for. So without being too cynical about this, you need to be aware of that. And it's a bit of a sad reality, but that's what we're going to be faced with. A lot of people asking around this will be looking at, will have a financial interest in it as well. And that will, I say, it'll make people not just cloud their judgment, but it'll also make them very vociferous and very demanding, I suspect, as well. So we spoke earlier on what the access to health records talks about. It talks about a right of access to certain individuals. So it says here, certain individuals can access certain parts of the deceased record so they can perform their duties in relation to the estate. It is not complete access. Really important. I'll emphasize this a couple of times as we go through this bit now. No one has complete access. No one says, can I see this person's record? And that's a very big difference to Data Protection Act subject access requests, for example. So an individual says, here's a subject access request. I want every single bit of information, and legally they're entitled to have every little scrap of information that you hold on them. This is totally different. This is saying you can have access to the bit that you need that's in relation to what you're doing, and you have to tell us what you need as well. It is not a case of saying, can I have access to this person's record? Okay. So the people, again, who have these rights of access are the executors who are named in the will. If there's no will, someone will have a letter of administration, and anyone who has a claim against the estate. And in those situations, the individual must be able to state what their claim is and what they believe is in the record to support their claim. Basically, why they need access and what their expectation is that they're going to get. Okay. So how a request would be made to you as we move forward. Some of the practical bits here, I think we'll define better as we start doing these. You know, I've seen obviously some areas already do this. Secondary care already have this concept in place, and a lot of organizations will have a performer. So, you know, as you may do with subject access requests, you don't have to get people to fill them out, or people don't have to be required to fill them out, but it's quite useful. And obviously if they're wanting to have access, it kind of reminds you of all the bits that you're going to need if you fill out a form. So we'll probably look at designing one. I'm not suggesting that you all need to design your own forms. We'll perhaps look at putting a template together that we can share out and that everyone can have, but a request must be in writing. Okay. And if the person states they're executor, they've got to produce a copy of the will to prove that. If they're administrator, they should have letters of administration. Oh, I thought it was going to be another bit there, sorry. So yeah, basically they've got to prove to you who they are, what their role is, and you know, by giving you the documents and letting you see the documents there, and putting that request into writing as well. So what they must provide to you, proof of their identity unless you already know them. So if they're already a patient at the practice, you know, and it's perhaps one of their relatives, you don't need to go through that. But you need to know the identity of the person. So if you don't know who they are, if you're not sure, you ask to see their identity. And then what information they need to carry out their duties. This is for the first two, obviously the executors and the administrators. What is it they need from the certificate, from the record? You'll have a death certificate, which is probably what most people need to do probate and things like that. Why do they need to get access to the record itself? And like I said, just putting a reminder there, it's not complete access, and no one's going to need to say, I just want to see it. I want to see what's in there in case there's something in there. That's not sufficient. That doesn't meet our requirement for us as a healthcare system to maintain the confidentiality and the duty of confidentiality we have around these records. If it's information for a claim against the estate, so someone's making a claim for whatever reason, they need to be able to say what they believe is in the records that would support their claim. It's not enough to say, I want to see the record to see what's in there. They need to say, well, I believe that this is going to be in there. Okay, it's a very different emphasis on it. And there is a concept here that if the claimant believes that the deceased signed a new will where they were not competent, and they'll be entering the record to support that. So I think a very simplistic example would be elderly person perhaps has an entry in their record to say that they're confused and not potentially competent. Some months after that, they sign a will giving all their money over to a person who they never really knew before. I don't need to go into these probably in too much depth. I suspect we're all clear what the type of situation we could be talking about here. That would seem to be an appropriate reason for a claimant to see what the entry would be. Is there an entry that supports the fact that the person has, wasn't competent to make the new will? I suspect that's quite a common one. I got this. I did get this from a presentation that was done in secondary care where they'd been doing this sort of stuff for a long time, and therefore I suspect that the fact that that was in there suggests that it's quite a common thing to happen. But again, these are the sort of things that as a community we'll get to know across GPs. You'll start to see these requests coming in, and we'll start to see the type of things that we're going to get. Okay, what information can I withhold? Even once you've got the right person asking, and is it legitimate for them to ask these questions, what can you legitimately withhold? So third-party information other than those involved in the deceased's care, and information that may cause serious physical or mental harm. Those two are exactly the same as the subject access request exemptions. So when you're doing a subject access request, they're the two exemptions that you look for. They're the same under the Access to Health Records Act. Information that the deceased wished or expected to remain confidential. To most people, that second bit, what would you expect to remain confidential? That would be the full record. I would expect that my full record in general would remain confidential, and and that was it really. I shouldn't probably have to make a specific request, although again there are examples of patients that do that. Patients in their final final element of their lives may well say, oh, I want it recorded in my record that I don't ever want my wife to know certain things about me, my partner to know certain things, particularly things that may have happened previously in their lives, and that we need to respect that. I mean, I'm probably struggling to think of how those things would be disclosed anyway, given what we've just said about how the system will work. But patients may often make a specific wish around how they want their information to be used in the future, and it may be that someone says, I never want any of my family to know anything about my medical record. We need to respect that, and if that's their expressed wish, then that should be respected. And this is just a bit of a slightly odd one, that none of this now applies to anything that was before November 1991, which is when this act came into being. So none of the law essentially didn't apply before that. There was no concept of access to the record. Therefore, you can ignore anything before November 1991 if you have any think about patients, unless there's something specific there that clarifies something that's in the record. If someone had something happen to them in December 1991 that just says this is a follow-on from that thing that happened 2 months earlier, then clearly if you have that information, you probably need to give that, because it brings two bits together. But yeah, nothing needs to be done before November 1991. This is a difficult point here, and I know from speaking to a couple of colleagues, and actually it's something that you see already. I know I occasionally get questions from practices about, almost in the immediate aftermath of someone having died, immediate family will come and say, can you tell me what happened in the final hours, or that type of information, and are they entitled to have that? And I think it's an area where the law would kind of struggle anyway. I don't know how you could write that into law. And as it says here, this is a direct link from the BMA document, which I will put a link to as well, which exactly says how this works. So this is a link to it, and I think it explains it quite well, that people do have a wish to know, particularly if they weren't there necessarily, or perhaps it happened and they weren't immediately aware of what happened. It's a natural thing to want to know how a close relative passed away, and this can be done in a in a sort of controlled way, and it's likely, as it says here, it's likely to be what the deceased person would have wanted anyway, and refusal is going to cause problems and exacerbate suspicion, as it says. So I think that's quite a good paragraph, which is why I wanted to put the whole thing in. I think if you ever read through that, now the only thing that I've then added on, because I think this could actually help us an awful lot, you'll be aware, I suspect, of the role of medical examiners, which is just being brought into play. So medical examiners will be looking at all deaths, including, ones that go to the coroner will go to the coroner anyway, but essentially every single death will be reviewed by a medical examiner. And this is a role which I've seen documented for them, that they may be involved in doing this, because they will have access to the record right up to the point of death, and talking to immediate family after someone has died is a role that medical examiners, certainly from the documents that I've seen, will be involved in, and therefore this may be something that they would want to take on. But just so you're aware, it's not really covered by the law, as I said, because it's probably quite difficult to actually describe in law. But I think it's set out fairly clearly there that you have that discretion to be able to disclose where you're comfortable with doing so. And at different practices, if you want to put in some sort of process, but have some perhaps an approval, if someone comes in, a lead person, a lead GP, for example, perhaps who might deal with this sort of stuff. But I say that's a difficult one to define in law, but it is something you need to be aware of. Okay, a couple of final bits, I think, really around how the system will work. Can I charge a fee? Nope, afraid you can't. Just like subject access requests, you can't do that. And you have 21 days to respond. Although absolutely don't worry about that. Certainly in these early days of it, don't get tied up with times and stuff. Okay, that's all I've got. Let me come back to you guys. So are there any sort of immediate questions that jump out at that point?
Yes, please, Barry. What's the status with regards to the Lloyd George and the paper? Do we still send those back to PCSE or not?
Sorry, I'm slightly struggling to hear that.
You say in terms of the Lloyd George envelope that we keep on the patient and any continuation cards that may still be in there from previous records, do we still send those back to PCSE, or are we expected to keep those too?
Yeah, I think that's still one of the unclear questions, because we haven't had a specific process. Literally what I've shown you on there, those couple of paragraphs, are all that we've seen at the moment, and the email from PCSE that said this starts yesterday. To me, it doesn't make a whole lot of sense to be sending stuff back to PCSE, because actually you're still going to be in a position where you'll have a split record. So if someone comes to you and says, I want to know something about this deceased person, you'll still get in a position then of saying, well, we've got the electronic bit, but those guys over at PCSE have got the paper. So you're going to need to ask them as well. Yeah.
Which then creates obvious difficulty with storage problems, doesn't it?
It does. Yeah, it does. As I say, it isn't. It isn't clear. I can't. I apologize. I don't have an answer to this, or to the question about, do you have to digitize everything? You know, what are you guys going to do with the paper elements that you've got? It is a huge question, and I don't know the answer, I'm afraid. It's one of those I'm pushing to ask that, and to hopefully get a response for you. But at the minute, I simply don't have that. I suppose all I can suggest is carry on. At the moment, I wouldn't destroy anything or stop sending. Sorry, I would stop sending, so stop printing off the record. Certainly, that's absolutely clear. I think you still send the Lloyd George back, as Tony says. This has just changed, so I do think you still send the Lloyd George back with whatever paper element you've got. It would be my suggestion. But I'd hope that we get that clarified very soon. Is all I can say, and I'm certainly pushing NHS England to do that. Let me just.
That sounds absolutely insane, Harry. That sounds absolutely insane. You know, it was bad enough that we had to print electronic into paper, and then now we have keep the electronic. Then we send. The way I had understood is that we were just going to have to keep the whole of the records, because if somebody does come, if we are going to have to deal with any requests from now on, then I would have to contact PCSE to ask them for the old paper records if there's anything on those records. So if I'm being responsible for doing the access to records to deceased patients, then I was assuming that we're keeping everything, because otherwise you're just adding work. Well, you're adding work for us, and also I do believe that. Sorry, I'm chatting now, but I do believe that the reason we're being told this is because there's no money on it for PCSE, and there's a lot of work involved. And the few cases that I've had that we had to deal with because PCSE had lost some of the records, so we had still our electronic records, and it's a really uncomfortable situation to ask the patient, actually, I need to know who is the executor of the will or who's administrating their program, the death, because it is a very difficult thing. Anybody that has been on that end will know that it's not a simple process. And I always involve the MPS or the MGU.
Yeah, thanks, Mercedes. I certainly don't disagree with the fact that it's complicated and it's going to be resource intensive. You're going to need to have people who obviously who know what they're doing and know how the system works. My frustration is that I can't tell you this is exactly how the system works. You do this, 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 and this, which is, you know, to me, that's the first thing we've got to get clear. You know, I've looked at some of the stuff in the chat there, and you're right. There is different guidance. I looked on the PCSE website yesterday. They've changed some bits, but not other bits. And NHS England haven't really said anything. So I think my focus at the moment was really just to give you this kind of high-level update, an introduction to the Access to Health Records Act and what it is and how it works. I need to focus on pushing to get this process. So do we know exactly what we're doing? Because that's the first one. I can't be come out here saying, well, it's this, and this, and then finding out actually, you know, it's something different, or it might be this, or it might be this. We need to know clearly what the process is, who's responsible for what, and how it's going to work. And then, you know, we can get into the practicalities of how it works. Do we digitize more records? What's the legal status of the Lloyd George? Does it go back? All these questions that we've still got. And then obviously dealing with the new bit, which is your requests for access to the records themselves, which, as Mercedes says, is going to be complex and difficult. You know, I was perhaps being over cynical when I made my point about money and so on. It'll be an emotional time for people who are looking at getting access to records. But I also think we need to be clear about what the limitations on access are, that it isn't necessarily next of kin, you know, immediate family. They can have that first bit, as we spoke about. I suspect medical examiners and probably yourselves can do that immediate, you know, how did the person die, and that, those sort of questions around that. But when you get into the bigger questions around legal discussions and so on, you know, you have to be fairly careful about this, and you know, it's going to be very much a judgment on a case-by-case basis at times, I suspect, and that's the element that's going to bring in more resources, you know, like than just simply looking on the system and pressing print for the full record and sending it away and giving the job to someone else to do. It is a complicated job. It's a legal task that has to be done, you know, to a proper standard. And as I said, and because in many cases money will be involved, it needs to be done correctly. But we need, and to enable us all to do that, we need to know exactly what we're supposed to be doing in the first place. So yeah, I see managers put in the chat from the PCSE's FAQs. They said that the PCSE will still collect paper and Lloyd George envelopes, which I think, as we said, doesn't really make a whole lot of sense, because you're still splitting up the record. Then you're still going to have an element of record that when you get asked for it, you can say, well, if you get a legitimate request, yes, this is, you know, this is our answer. Here's the information that you're allowed to have. However, you need to be aware there's still a bit of the record that we don't have. There's the paper bit that we sent back to PCSE. So instead of the situation right now where hopefully we point people to PCSE because they've got the full record, the paper and the printed electronic stuff, it's going to be split. It's almost made it more difficult in that there are two elements of the record being held separately by different organizations. What have you already sent the medical back? So my understanding is you're not the current situation where PCSE will say that you're responsible for the records. It's just their view on it. It's not a legal opinion. It's their view to get them out of it. And if you've seen the guidance I've given, I absolutely don't agree with it. You pass it back to them. Anything before the 1st of August is their responsibility. They have the paper record. They have the full record, the printout from the electronic record that you've sent them. So they have the full record, and it's their job to deal with it. And I know that they have this thing where they say you're responsible for them. You're not. But that's only up to the 1st of August. Clearly that the process has now changed and you are responsible for it, but it's hard to see how you can be responsible for the bits that you don't have. You know, you're still going to have that bit where if they're requiring you to send the paper and the Lloyd George away, then essentially you split the record at that point. Okay. Anything else from anyone? I think we could probably go around in circles discussing it because the reality is that we don't have clarity on it yet, which is difficult. And all I can promise you guys is that I'm pushing them all the time for this. If there's anything specific that you've got, any queries that I haven't covered off on that presentation, please let me know. Anja, I'm sorry, I don't know the answer to that last question because I don't actually really know about how PCSE work with their labels and things like that. So unless they've put it on their website, I haven't seen very much from them other than they've changed a few bits of their website. And I saw they put some stuff in the FAQs, which it didn't really, I didn't think was very helpful, to be fair. But I'm sorry, I don't know how they work with their labels and so on. Again, I've asked NHS England to kind of go to PCSE. I know we don't get anything. I certainly don't get anything in my experience going to PCSE direct saying, what's your policy on this? How are you doing this? They will just refer back to, we comply with the contract we get from NHS England. So the route I tend to go is to try and ask NHS England, who are the contract holders and essentially are the management for the PCSE contract. I ask them what PCSE should be doing. And that's my route at the moment. I'm asking them what have they changed in the contract and what should they be actually delivering on now. But I'm sorry, I don't know how they use their labels, I'm afraid. So I'll continue to do that. I hope this morning's been at least useful to you going forward. I suspect, going forward, we will do more of this. It is coming this way, to you guys. It's my understanding. It's just a bit fragmented at the moment, and hopefully once we get it sorted, we'll be able to give you some more detailed and better explanation of how the system should work. Okay. Thank you very much. Then I'll put the presentation up fairly soon and the recording of the webinar as well, if anyone wants to pick out any bits on it. But as I say, if you've got any queries, just let me know and I'll add them to the list that I've already got. Okay, thank you all very much, guys. Thank you.
Thank you.